Very good morning, ladies and gentlemen, distinguished dignitaries, both on and off the dais. It's very heartening to see so many of us, despite the flight cancellation and other problems we had. And a very warm welcome to the participants in the first Indo-German Arbitration Conclave on exploring bilateral avenues for efficient solution, hosted by the Bar Association of India in collaboration with BRAK, DIHK, DIHK and NPSC. And I especially welcome our chief guest, Honorable Justice N. Anand Venkatesh, a judge of Madras High Court, our presidents and office bearers of Bar Association, BRAK, DIHK and NPSC. We'll be with the welcome address, followed by brief remarks from our institutional partners and then addressed by our chief guest. So may I now invite Mr. Amarjit Singh Chandiok, our President-elect, to give his welcome address.
Thank you, Mr. Bedi. I'm not calling to Amarjit. My Lord, Mr. N. Venkatesh, the dignitaries on the dais and off the dais, I have an honorable former judge of the Madras High Court also here, my colleagues in the Bar Association of India, and our friends from the Chamber of Commerce, and others who have joined us today. Welcome you all to this conclave, or arbitration conclave. A little while ago, somebody asked me a question, would arbitration include mediation? I said yes. Every part of the world is part of it. The Indo-German bilateral trade has touched all-time high with US dollar $33.40. Indo-German trade in service areas also gone up by 15%. Germany was the 8th largest investor and participating in India. And Indo-German have two fast-track mechanisms already in place. The Arbitration Act in Germany is 1997, we have it 1996. Therefore, we are together. They have a mediation act, we have a mediation act. So everything is in place, but we still need to work out what do we need to do to ensure, especially with respect to the eminencies, the people who are not having very large disputes, how we can resolve them. And this bilateral meeting would help us to establish a chapter, establish something between us, so that it helps us to resolve what we need to do it urgently. I welcome you all and look forward for debate throughout the day and see what do we come out of it with the ultimate solution to see how do we resolve these disputes bilaterally. And of course, enforcement is a big challenge of awards. And if we can find out a mechanism, bilateral by some MOU or some bilateral agreement between us, it will help us further do that. We have Indo-German Chamber of Commerce being represented. We have other people representing here. So I think there will be a very fruitful discussion for us to see how do we take this relationship between Bar Association of India and them to a destination. Welcome you all. Have a good day.
Thank you for that quick introduction and a welcome to all. May I now request our President of the Bar Association, Mr. Prashant Kumar, to give his remarks.
Honorable Justice Venkatesh, Honorable Justice Rajendran, former judge of Madras High Court, my colleagues from Bar Association of India, from German Federal Bar, from the Chambers of Commerce. I think we are starting something momentous here today. That is a bilateral meeting on the subject of dispute resolution. The Bar Association of India has entered into MOUs with 29 national bar associations. But we have chosen to start this series of dialogues with our counterparts in Germany. That is because India and Germany enjoy a very strong economic relationship and very deep and abiding cultural and historic ties. I may highlight that we take pride in our ancient literature and Vedas, but it was Max Muller, a German, who rediscovered the Vedas and exposed them to the entire world. So that way, we are bound together by a shared intellectual tradition as well. Germany is the biggest economy in Europe, and India is the fastest growing large economy in the world. Both share similar ethos of democracy and the rule of law, and are natural partners in more than one way. That is why taking forward this collaboration through dialogue and to deepen understanding, not only to do business, but if the disputes do arise in the course of doing business, how to address them, not generically, but in a manner where we have the understanding of complete ecosystem, each other's legal culture, business culture, and how a dispute fits in the entire economic relationship. Because resolution of dispute is not merely through the standard methods of arbitration, mediation, but also through dialogue, where gaps can be identified, gaps can be filled, and on top of that, if we can institutionalize such approaches, where before going into dispute, there are avenues to talk together, there are avenues to address those problems which arise sometimes in due performance of contract, which may not be strictly legal, which may not be with an intention to cause a breach. So how to repair that relationship before going into dispute? How to see that the performance continue to be, performance of contracts continues to be there. So this can only be addressed by the chambers of commerce, legal profession, and the entrepreneurs coming together and structuring a platform where these things can be addressed. We are here at Chennai, and we are very happy to be here in Tamil Nadu in Chennai, because Tamil Nadu is emerging as a very strong linchpin of India's economic activity. A number of foreign companies, including from Germany, have chosen to set base in Tamil Nadu. It is also because of the excellent education system and availability of skilled manpower in this part of India. And that's why we thought that instead of going to the usual spots like Bombay, Delhi, Bangalore, we should come to Tamil Nadu, where this ecosystem is growing, has a very good support from the judiciary. Madras High Court, in terms of dispute resolution, is one of the very progressive high courts in the judgments which have been rendered to support arbitration. So this event will also try to generate more awareness that when you choose a place for doing business, how is the legal setup, what is the judicial support. So we have come here, and this, I think, will be one of the first in the series of such dialogues. We'll be going to Germany next year to continue this, and we hope something concrete, something useful comes out of these deliberations as a beginning of a new initiative and a new thought process. So once again, I welcome you all, and we will have three interesting working sessions touching in progression from economic relationship to dispute resolution to how to build institutional bridges so that the dialogue is intensive and progressive. Thank you very much.
Thank you, President. It was very insightful and exciting to hear that next year we continue and we go to Germany on that. Now may I request Ms. Svetlana to give her remarks on behalf of BRAK.
Distinguished colleagues from the Bar Association of India, Your Excellencies from the Judiciary, honored speakers and guests, and ladies and gentlemen. I'm very happy that some of you I can already call friends, and I'm very happy to see you again. On behalf of the German Federal Bar, it is my great pleasure to address you this morning. We are deeply honored to be part of the Indo-German Arbitration Conclave, and we thank the Bar Association of India for putting together this important event and for bringing together such an impressive group of legal arbitration professionals. Commercial relations, how Prashant just put it, between India and Germany have been growing steadily in recent years. And with them, the number of cross-border transactions, partnerships, and investments. In this dynamic environment, effective mechanisms for resolving commercial disputes are not merely a supporting function of the economy. They are a precondition for trust, reliability, and long-term cooperation between businesses. The theme of today's conclave, exploring bilateral avenues for efficient commercial dispute resolution, is therefore very relevant. We are also honored to be once again joining hands with the German Chamber of Commerce and Industry, this being our third collaboration in the Asia-Pacific region, to advance dialogue on a subject that continues to shape the global businesses and legal landscape. For the German Federal Bar, 2025 is a significant year. In April, we had the privilege of signing a memorandum of understanding with the Bar Association of India. With this agreement, our organizations expressed a clear joint commitment to strengthen professional exchange, encouraging mutual understanding for our legal systems, and building sustainable institutional cooperation. Today marks our very first time that this agreement is being brought to life, and we are delighted that it begins with a deeply practical and forward-looking discussion on commercial arbitration. Before we turn to the program of today's event, I would like to briefly introduce to you the German Federal Bar. The German Federal Bar is the umbrella organization of the legal profession in Germany. Its members are the 28 regional bar associations, which act as the supervisory body of the legal profession in their respective region. For more than 60 years, the German Federal Bar has represented the interests of the legal profession at a national, European, and international level. With the expertise, competence, and experience of lawyers from a wide range of professional environments and organizational structures, our organization is committed to safeguard the rule of law, strengthening independent professional self-government, and protecting the core values of the legal profession. The German legal profession plays not only a key role on the national level, but engages on the international stage in shaping legal cooperation and promoting intercultural dialogue in the field of law. We fulfill this role with our partner organizations from nearly all parts of the world. And again, I'm truly happy and proud as well that this year we embarked on a new cooperation with the Bar Association of India. International legal cooperation is important because it enables countries, institutions, and legal systems to work together effectively when dealing with issues that cross borders. or entire joint or require joint decision-making. In a globalized world, business relations, political and social matters often extend beyond one jurisdiction, and cooperation ensures that justice and governance improve and remain fair and functional. International legal cooperation facilitates international trade and investment, indispensable for vital markets. Common legal standards and dispute resolution mechanisms create stability for global business and attract international investment and trade. Thus, it creates opportunities beyond what domestic markets alone can offer. Events like today's are therefore not only significant for the legal professionals, but have a much broader impact. I think we seldom realize this. But when we do, it should make us excited and also a little proud. Instead of turning inward, as is sadly increasingly common globally, we remain committed to engagement and collaboration. And in this spirit, I wish all of us an insightful and interesting event. Thank you.
Thank you, Svetlana, for telling us about the German Federal Bar, how it works. But not many would know that actually it's Svetlana who's the driving force behind this Indo-German Arbitration Conclave. She has pushed it with our president and made it happen, and we hope it continues. Now may I request Professor Dr. Stephen F. Warnick to come and give his remarks.
Honorable Justice, distinguished guest, ladies and gentlemen, dear colleagues and friends. On behalf of the German Chamber of Commerce and Industry, it is a privilege to extend a warm welcome to all of you. This distinguished gathering in Chennai, we are honored to join forces with the Bar Association of India and the German Federal Bar in bringing this important dialogue on arbitration to life, a subject, I dare say, of strategic importance for global commerce. Why Chennai? Chennai stands out as one of the most dynamic economies worldwide and a trusted partner for German industry. Chennai, with its thriving industrial ecosystem and international outlook, provides an ideal setting for discussing mechanisms that underpin confidence in cross-border transactions. So, briefly summarizing, this city symbolizes innovativity and connectivity. In today's interconnected markets, economic success is inseparable from legal certainty. Businesses and lawyers are not merely stakeholders. They are strategic partners in fostering trust, mitigating risks, and finding fair solutions. This partnership, in our mind, is essential for sustainable growth and for providing a predictable environment for investment. As negotiations on the free trade agreement between India and the European Union progress, and obviously I have to mention this topic because we are fighting hard from the German side to make it a success. And we are hopeful that in January this EU-India free trade agreement will be concluded. As negotiations progress, the importance of robust dispute resolution mechanisms cannot be overstated. Only arbitration provides the neutrality, the flexibility, and enforceability that businesses require to operate confidently under evolving trade frameworks. It is a cornerstone for stable and predictable business relations, especially in times of regulatory transformation, and I understand that there are lots of transformations in India as well. A word of thanks. I would like to express our sincere gratitude to our partners for the excellent cooperation in preparing this summit, in fact, this conclave, which means that obviously we are going to discuss in a very, very cultural manner our topics. So thank you to the Bar Association of India and the German Federal Bar, especially the commitment of the Bar Association of India, and dear Prashant Kumar, it was a pleasure to work together with you, made this event possible, and together we are setting benchmarks that will benefit enterprises and legal practitioners alike. I very much like the Indian saying, the world is one family. Today, this spirit of openness and partnership is exactly what brings us together in Chennai. And it has been said here just a couple of minutes ago that it is a cultural dialogue. It is a dialogue between India and Germany. It is a dialogue between the business and the legal community that gives us trust and hope. And it is exactly in this spirit that we are joining discussions, and I wish all of us a very fruitful conference. Thank you very much.
Thank you, Professor. We look forward to this free trade agreement with India and Germany. Now, before I call upon our next guest, I just was having a discussion with him, and he related a very interesting story about Egypt and cultural differences. Perhaps he will talk about it. So may I request Mr. Jan Neuther, on behalf of AHK, to give his remarks.
Honorable dignitaries, distinguished guests, I could start by saying I'm one of yours. I returned to India. I live in India. I returned 4 months ago. I lived in India 28 years ago for 3 years. Everything is different, but everything is very, very exciting. Now what we heard so far makes me excited to be allowed to spend the day with you, and thank you very much for having me. I'm really blessed to spend today in beautiful Chennai. And Chennai, of course, needless to say, we run an office as well. But allow me to give you a little bit an idea, this German Chamber network, how does it work? We do have activities and offices in 92 countries with 150 offices. We do have an indirect touch through our sister chambers of commerce in Germany with 3.9 million companies in Germany. So as we consider ourselves a networking community in India, the same holds true for Germany as well. The German Chamber of Commerce today, represented by Professor Wernicke and Ms. Ting Wintaro, is essential to be the link to all of us in 92 countries, is essential to be the voice to us so we understand what are the concerns, what are the opportunities of the German businesses in Germany, and we can direct our strategies along these kind of strategic moves. Now, we are very, very certain that despite having around 2,000 German companies and 6,000 European companies, 2,000 German companies in India already, that we are at the start of something bigger. Of course, the free trade agreement is going to pave the way. However, it's not the free trade agreement as such, it's India to create a strong interest in Germany and to make a lot of mid-sized businesses, particularly mid-sized businesses, to reach out to us and to ask us how can we engage, how can we get into a prosperous partnership with our Indian friends. So given that, the main thing we have to make sure as a Chamber of Commerce is dialogue, transparency, since dialogue and transparency leads to trust. And trust is a basis of a long-time prosperous relationship, and I believe I don't need to tell our Indian colleagues in this room, since you experienced lots of projects with German counterparts, when we come to a conclusion, we stick to that conclusion, and we stick to it long term, irrespective of whether the sun is shining or whether it's raining like a couple of days ago. We'll stick to partnerships. And the Indian mentality is exactly the same. That's why it's a wonderful fit. 3 more sentences, I'm done. who are we in India? So first of all, we are the biggest bilateral chamber to be active in India. Yeah, we have around 3,000 members. We run 6 offices, needless to say, of course, 1 office in Chennai as well. And yeah, we take care of a huge, huge bundle of services, of initiatives. And this is why it's so important for me to be here today, since what you may not know is the Indo-German Chamber of Commerce presently operates only in a facilitative capacity in the field of arbitration and mediation. We are active in that field. Yeah. However, we are active in that field primarily serving as a neutral platform for Indo-German commercial dispute resolution. That means we lay down the rules of arbitration process, arrange premises and facilities, such as conferencing rooms, storage or documentation for judges, the travel arrangements. So we are active more or less in the field of, let's say, administrative assistance. But we created a body. And now how, and that is our challenge, given so many tasks we have, and not being experts in the field of arbitration. We have exactly 1 person in-house to be an expert in that field. How do we foster our dialogue in order to allow us to engage more? How do we create transparency and form partnerships? In this sense, I wish all of us a fantastic conclave, and I go back to Mumbai later, and I will report to that 1 person, making sure there is dialogue. Thank you indeed.
Thank you, Mr. Neuter. Very interesting insights, how Indo-German Chamber of Commerce is trying to do. Now, before I call Mr. Raja, I just wanted to inform how we got him to come today. And I spoke to Mr. Datar about collaborating with Nani Palkhivala as we were discussing, arbitration center. He immediately, without hesitation, called up Mr. Raja there and then from the courtroom and requested him, and he was very kind to accept that. So may I now request Mr. Raja to give his remarks.
Good morning, friends. Good morning, friends from Germany. Good morning to Germans living in Chennai. Good morning to friends of the dais, on the dais. We are gathered at a time when arbitration regime in India is acquiring a reputation for being conference-friendly and practice-unfriendly. I, however, feel that every conference gives us opportunity to track the evolving contours of the arbitration regime in India and to not only take stock of its effectiveness, but also to walk away from the conference with ideas of how to improve the regime further. I am sure that this conference will be no exception. In this very brief presentation, I shall focus on how we need to integrate more of technology into the arbitration regime to make it more effective and efficient. As practitioners of law, we frequently bemoan the sorry state of infrastructure that the state provides to support administration of justice in conventional courts. In the All India Judges Association case, the Supreme Court of India observed that it is imperative upon the state to provide the judicial wing with the requisite infrastructure commensurate with the constitutional obligation of the judiciary. We have no dearth of reports and recommendations that points to where the state falls short on this score. These reports record the pathetic condition of conventional courts and the dismal infrastructure available there. Crowded court halls, squeaking furniture, obsolete computers, lack of even functional printers, lack of UPS backup, lack of LAN ports, lack of functional Wi-Fi connectivity, insects-infected books, inadequate stationery have all been marked out for attention in the Shetty Commission report of 1999. Also, in a recent study entitled Empirical Study to Evaluate the Delivery of Justice through Improved Infrastructure, the Ministry of Law and Justice points out to severe such deficiencies continuing even today. While the need for addressing these inadequacies is important and pressing, private administration of justice must not suffer the same ills as public administration of justice. Arbitration centers must therefore not fall foul of the very same defects that traditional courts are faulted with. In fact, it is necessary for arbitration courts to take a giant leap in integrating technology so that its traditional courts may learn to emulate these examples. The arbitration landscape is evolving rapidly, with technological advancement acting as a major catalyst. I don't think we have a choice there, because the current score is about 6 crore cases pending in various courts in India, but even that is a gross understatement because we are only looking at conventional courts. Within the city of Chennai, there are 32 tribunals. When you take stock of the backlogs in courts, you do not take stock of the backlogs in tribunals. You do not take stock of backlogs in private justicing systems like arbitrations. So without all this, it's about 5.5 to 6 crore cases, which is absolutely mind-boggling. This year's Dubai Arbitration Week, particularly the DIHK Symposium, offered a clear illustration of this development with DIHK's introduction of its new arbitration case management platform, DANA by DIHK, powered by Opus 2. The adoption of this platform marked a technological upgrade. It signaled a broader shift in how arbitral institutions view their role in the modern dispute resolution ecosystem and how arbitration case management is evolving. The symposium's theme was Shifting Sands, Certainty in an Uncertain World, focused on how arbitration and ADR can provide clarity amid global unpredictability. Arbitration institutions are uniquely placed to offer that certainty and state-of-art arbitration case management platforms. Revolutionizing internal administration and user experience sit at the very epicenter of this transformation. Arbitral institutions have long been valued for their service quality, procedural consistency, neutrality, administrative competence, and their commitment to promoting ADR. These qualities remain essential, but today, on their own, they no longer are enough. The next decade will belong to arbitral institutions that combine procedural expertise with digital capability, operational agility, modern rules, and user-centric designs. Technology is no longer an optional infrastructure. It is becoming a defining part of the arbitral institution's identity and competitiveness in a crowded market. Advanced case management platforms, arbitration case management platforms now include AI-enabled tools, real-time access to case information, secure centralized communication and document exchange, streamlined workflows, efficient case filings with automated payment systems, robust security safeguards, intuitive modern users experience, agile solutions that evolve with user needs. These developments do not replace human judgment or institutional oversight. Far from it, they allow arbitral institutions to focus their expertise where it matters most while reducing administrative friction. DIHK's introduction of DANA by DIHK, powered by Opus, is one example of this broader industry shift towards arbitration case management, but the movement is global. Other arbitral institutions, recognizing the advantages of modern technology infrastructure, have recently announced major steps in digital transformation, including the launching of ICC Case Connect powered by Opus 2 and SIAC Gateway powered by Opus 2. I must declare at this convention that Nani Palkhivala Arbitration Center has signed up an MOU for developing its own indigenous Indian platforms to handle these very many challenges that the arbitration regime poses. And in about 2 months' time, I can assure you that we will be able to offer you some of the best technological platforms for conducting arbitration here in India. The challenge is because the Indian arbitration regime is so different from what you have in other Western countries. I can think of 4 different baskets in which these are nurtured. One is, just take NBFC arbitrations, non-banking financial arbitrations. You have 20 lakh arbitrations happening every year in India. And then you have statutory arbitrations. There are at least 32 central legislations which mandate arbitrations, which are never taken into the reckoning when we talk about various amendments to the Arbitration Act. Then 3, you have institutional arbitration, and 4, you have ad hoc arbitrations. So you can't use one-size-fits-all approach. You need to design and come up with platforms that can cater to each of these requirements separately, and that is what NPAC has embarked on a voyage to achieve. Thank you all for inviting me. I'm sure today there is going to be a lot of discussion about this, and I hope to go away with a lot of information and knowledge about how we can improve the arbitration regime here in India for us and for, of course, people who have come abroad and who hope to tie up with us to provide better systems for deciding arbitration disputes. Thank you.
Thank you, Mr. Raja. What an insightful information on technology and arbitration and how India is at the forefront and NPAC is working on it. Our guest of honor, Mr. P.S. Raman, the Advocate General of Tamil Nadu, could not be here today, but he has shared his message. And if we can put it on the screen, or if I can just read it out, it's a short message. It's heartening to learn that Bar Association of India is organizing a bilateral Indo-German Arbitration Conclave in collaboration with the German Federal Bar and German Chamber of Commerce on 6th December. A panel of very eminent speakers are taking part in the working session, and I'm sure that the debates in the conclave would benefit exploring bilateral avenues between India and Germany for efficient commercial dispute resolution. India and Germany are 2 highly industrialized countries which are shared common business interest. I'm sure this conclave will be an extremely productive forum for the business enterprises to reach out towards better commercial dispute resolution. As much as I was looking forward to attend the conclave, a clash with another important event which requires my presence has prevented me to this pleasure. I wish the conclave all success and once again congratulate the Bar Association of India. So with that, we miss him, but we shall continue and hope he can join us in the next conclave. Before I call upon our chief guest for his address, may I request Mr. Maratha to felicitate by giving a bouquet to our chief guest as a token of our love, and for him taking time out on a Saturday to come and attend this. Mr. Maratha. May I now request Justice Venkatesh to give his inaugural address.
Good morning to all friends who have assembled here, dignitaries on the dais, off the dais, and my special hello to those who have come from Germany and those who are living in Chennai also. All the speakers before me, they have addressed the objective of this gathering, what is their expectation, how they propose to move on. I am somebody who on a daily basis keeps on dealing with disputes, so I would directly jump into that. More so since I may not be able to stay behind for all those deliberations which you are going to make. So probably what I am going to address now may also form part of whatever you discuss in the course of the day. It is pertinent to note that the 3 systems of law that is applied in any international commercial arbitration proceedings are: 1, the law governing the substantive contract, which is also called as the proper law of contract or the law governing the substance of the dispute. That is one. Second is the law governing the agreement to arbitrate, which normally is referred to as the governing law. And then the third one is the law of the place where the reference is conducted, which we call as the curial law. Insofar as arbitrability of disputes is concerned, I always think that the law governing the arbitration agreement assumes a lot of significance, and that's where most of the disputes are. I'll just give you a small illustration. Property rights disputes may be arbitrable in Germany. For instance, a declaration of title, an injunction, a possession, etc., whatever touches but it is not arbitrable in India. So a party who is based out of Germany may escape this arbitrability issue by choosing Germany as a law governing the arbitration agreement against an Indian party. I'm just giving you an illustration. So can the parties rely upon German law when there is a dispute between an Indian entity and a German entity, and the law governing the arbitration agreement is absent in the contract? This is exactly where most of the disputes arise. I don't wish that a dispute has to arise, but then when you go into business transactions, many a times that's the natural consequence of it, and we must have something effective to deal with it. So therefore I thought I'll directly touch upon it. See, the determination of the law governing the arbitration agreement in Germany, if I just had an occasion to go through it, I find that it was comprehensively revised in 1998, and it is closely in line with the UNCITRAL model law. I don't find a separate legislation for arbitration in Germany, and the provisions of arbitration is incorporated in the German Civil Procedure Code, which I find as ZPO. I will not be able to pronounce it. So it's ZPO sections 1025 to 1066 is what deals with it. So Germany is also a part of the New York Convention on enforcement of foreign awards. So originally, that's how the enforcement and the proceedings are conducted there. So first thing is determining the law governing the arbitration agreement. Under the German law, the courts have adopted a three-step method or a three-test process approach to determine the law governing the arbitration agreement. The first step is express choice made by the parties. That's the best. That's the best you can do so that you can focus on the real dispute without wasting your time on the process. But then we don't like it. We always like to agitate. So the second is implied choice of the parties. And the third is, in the absence of an express or an implied choice, the law governing the seat will apply. That's how it started in Germany. The issue is there is no clarity on what amounts to an implied choice. That's one step that was there. But there was a view taken by the Federal Court of Justice. I think it was somewhere in 2019, where it said that the law governing the substance of a dispute does not apply as an implied choice of the parties in light of the doctrine of severability of the agreement, of the contract, and the arbitration agreement having independent existence. So, the Federal Court, which relied upon Article 5(1)(a) of the New York Convention, said that to determine the law governing the arbitration agreement has to be based on the law of the seat of arbitration. Please come to India now. In India, we had one judgment of the Supreme Court which is popularly called as the Singer case, S-I-N-G-E-R, which is National Thermal Power Corporation as a Singer. This is of the year 1992. In Singer, the Supreme Court held that the proper law means the proper law, that's the law governing the substantive contract, which you always call as the proper law. It said that the proper law also applies to the arbitration agreement unless there are contrary stipulations to the same by way of agreement between the parties. So this perfectly aligns with the principles that were set out in two very famous English cases about which all of you will know. One is the Sulamerica case and the other is the ENCA case, ENKA. These are the two which were very closely in line with what was held by the Apex Court in the Singer case. But subsequently came the Constitution Bench judgment in BALCO. BALCO judgment was in the year 2019, where it was held that Part 1 of the Arbitration Act 1996 will automatically apply by virtue of India being the seat of arbitration. The consequence of this decision is whenever parties choose India as the seat, the governing law would automatically be the Indian law. So this was also upheld in the subsequent judgments. But then law is all about conflicts. There is change in people, change in views. Then came two conflicting judgments. The first judgment is in Arif Azim case. Arif Azim case was a case which came in the year 2024. There, the court in this case was to determine whether the seat of arbitration is in India pursuant to the agreement in dispute. This was the issue that was decided by the court. In the process of determining the seat, the court applied the Saussure principle and the doctrine of forum non-convenience. And the court said that the most appropriate criterion for determining the seat in the absence of an express designation of a place is the venue, provided there is no other significant contrary indication to any other place in the arbitration agreement. There is an underlying thing which I am continuously saying whenever I express the views is in the absence of parties agreeing, in the absence of contract providing. Right. So finally I will say, how do we avoid all these problems? So this is what the court said, applying the Saussure principle. So the closest connection test, this test is called as the closest connection test. It has to be applied to determine the place or the venue that is most suitable for determining the seat. When the arbitration agreement has two or more places designated in the arbitration agreement, then the courts will have to apply the doctrine of forum non-convenience, has to be applied. The place most suited for the interest of all parties and the ends of justice has to be followed. This is what the court said in Arif Azim. Then came a contrary view. The contrary view was taken in Disorta case, which was of the recent 2025 judgment. In this, the Supreme Court came up with this three test method. So, referring to Sulamerica, which is in consonance with your federal court case. So here the court said first, the Supreme Court of India said the first courts must look at the express choice of law for the arbitration agreement. Second, if none exists, they must identify whether the choice of law for the main contract was intended to apply to the arbitration clause. And third, if no such intention can be inferred, the law of the seat will ordinarily govern as it has the closest and the most real connection to the arbitration agreement. Now, the court referred to the Saussure principle as relied in Arif Azim. However, the court went on to apply the principles of Sulamerica and ENCA and gave the primacy over the governing law of the contract in the place of law governing the seat of arbitration. So, the mere choice of place is not sufficient in the absence of other relevant factors to override the presumption in favor of the law governing the contract. So therefore, while dealing with the determination of the governing law of the arbitration agreement, the court held in this case that the law governing the contract will apply to the arbitration agreement as an implied choice by the parties. So these two recent decisions of the Supreme Court has resulted in conflicting position of law, and it is yet to be resolved. Some food of thought for those who are practicing there. Yeah. So in Arif Azim, the court places, so to cut it short, in Arif Azim, the court places reliance on the place of arbitration to determine the implied choice of law, whereas in Disortho case, the court considers the governing law of the contract to be the implied choice of law and emphasize that the place of arbitration is insufficient to override the presumption in favor of the law governing the contract in the absence of other relevant factors. Therefore, obviously there is a conflict between these two. Looking at the entire thing, my conclusion would be that if there is a dispute between an Indian entity and a German entity, and the law governing the substance of the dispute is Indian law or German law, as the case may be, applying the ratio in Disortho case, which is the later case in 25, the law governing the substance of the dispute will govern the arbitration agreement. However, if you apply the Arif Azim case, the law governing the arbitration agreement will be decided based on the seat of arbitration. So if you apply the ratio in federal court case, the seat of arbitration will decide the law governing the arbitration. In conclusion, the findings in Arif Azim aligns with the law laid down by the courts in Germany. So there is one view which is in line with the law that was laid down in Germany. I just went through the German arbitration law also. I find that there is no distinction between a domestic and an international arbitration in Germany. Section 1025 of ZPO read with section 1043, which is in pari materia to article 21 of the Unis Citral. German law allows an arbitrator to determine the place of arbitration when it is expressly not contemplated by the parties in the arbitration agreement. So if arbitration is seated in Germany, then all the mandatory substantive laws of Germany have to be complied with. As otherwise, the award that disregards the mandatory substantive laws of Germany is liable to be set aside in violation of public policy. The German law does not distinguish between domestic parties and domestic and international arbitration, and it applies to all types of arbitration, alike with the exception of law of so and so. This is one thing which I found in your law. Then, the definition of an arbitration agreement in German law, I found that it has a very similar language as is used in the unicitral model law. It includes contractual and non-contractual disputes that have arisen or may arise between the parties in future. So, the other thing which I found is the seat of arbitration, which we very usually keep uttering on a daily basis in every other arbitration jurisprudence. In Germany, they don't use this word at all. In Germany, they use the word place. They use the word, am I right? So, they use the word place. So, what happens is that the parties are free to agree to any place of arbitration. That is the seat. So, absence of such agreement, the place of arbitration shall determine by the arbitral tribunal. The recent developments which I found in German law is the abolition of written form requirement for arbitration agreements. That's quite a risky proposition because under the current law, which is section 1031 of ZPO, it requires arbitration agreements to be in writing, either through a signed document or on exchange of letters, faxes, digital documents. And for your information, that's what section 7 of the 1996 Act also provides. It's the same in pari materia. And this also aligns with Article 2 of the New York Convention. Now the draft bill that is now proposed to be brought in, it proposes to abolish all these formal requirements entirely for commercial contracts. So arbitration agreements could then be concluded even orally and by conduct through course of dealing and through modern electronic communications. So the intent was to reflect commercial reality, align Germany with UNCITRAL and reduce disputes arising from technical format. The issue which I see is that there are, in the absence of a formal documentation, in the absence of a formal agreement, it would increase uncertainty over consent, formation and scope, requiring more judicial scrutiny in the law governing the arbitration agreement. It also risks non-enforceability under the New York Convention because New York Convention continues to say that it has to be in writing. So that is one. And the second important development which I found was the judicial determination of the existence or validity of an arbitration agreement. So what they have proposed now is a draft bill proposes a significant amendment to section 1032 of ZPO. It allows a party to apply to the court for a ruling on the existence or validity of the arbitration agreement at the pre-arbitral stage. The intent behind this would be to ensure that the parties have access to early judicial clarity. It also sought symmetry with the section 1040 of ZPO, which preserves the arbitral tribunals, the famous competence principle rule, on its own jurisdiction. So, under the proposed amendment, the tribunal could still rule on its own jurisdiction. The court could issue an early binding determination. The arbitration could continue during court proceedings, but would cease if the court ruled the agreement invalid. These are the three developments which may come out of this. This mechanism was intended to reduce wasteful arbitration and enhance legal certainty. But one of the major criticisms is that a pre-arbitral application to the court could be used strategically by a recalcitrant party to delay or derail arbitration. So there is also a concern of increased judicial involvement, which was always the objective. The objective was not to allow judiciary to get in, but then even at the start, you are now allowing a judicial intervention. So what has happened is that an increased judicial involvement will disturb the balance established by the rule of competence. To end with, I would only say that parties while entering into the contract, how do we avoid all these things? Whatever I said did not touch upon the substantive dispute between the parties on the merits of the case. It was beating around those procedural things as to where the seat is, where this is and that is. So the best way, what would be the best way? The best way would be the parties while entering into the contract must set out the clear language regarding the law governing the substance of the dispute and the law governing the arbitration agreement. It's so easy. Just put it there. If you put it there, all problems are solved. But don't believe lawyers in this. They would intentionally not put it there. So since there are persons who have come from business community, beware of lawyers here. It must set out the clear language regarding law governing the substance of the dispute and the law governing the arbitration agreement. And according to me, this will help the parties to avoid any unnecessary litigation or on determining the laws applicable to the dispute and arbitration. And before I leave, don't forget the fact that there are international egos which comes here, like the one which happened between England and Paris. This is this famous case which is called as the KFG versus Kebabji case. So the this KFG versus Kebab, I think I'm not taking too much of time. Yeah. So the reason why I'm saying is that I want to cover up all the other things which are going to happen till the evening in my absence. So, I will finish with this. So, this Kebabji versus this KFG is a very interesting judgment where it involved a conflict between two countries and how the fixed notions of these two countries actually made everything unworkable. So, this is something which I wanted to say to avoid such unworkable situations after having ventured into a situation like this. So, what happens is that in this case, KFG brought an action in the Paris court brought an action before the Paris court, and the tribunal concluded that French law, it concluded that the French law, KFG, under the French law, the KFG became a party and therefore it held against KFG. I don't want to get into the merits of the case, I just want to touch the crux of what happened. This was further confirmed in appeal, and what happened was the succeeding party, which is the Kebabji, filed an execution petition before United Kingdom Execution Court. This was resisted by KFG saying that whether the law governing the contract was English law, and if so, whether KFG had become a party to the agreement under the English law was the issue that was raised there. The decision was made by applying the French law in that case. The commercial court answered the first question in the affirmative and the second question in the negative. What is important is the judgment of the Court of Appeal. Court of Appeal said the Court of Appeal dismissed the appeal of Kebabji and affirmed the finding that KFG did not become a party to the contract applying English law. And this was also confirmed by the Supreme Court. So, as a result, an award that was passed in favor of Kebabji was not able to be executed in England. Let's see what happened in France. As you always see, English and the French have long been strange bedfellows on several issues of state. Yet most of these conflicts were usually because the sovereigns of these two countries. This time around, the judicial war of sorts was brewing across the English Channel. KFG's channel to the arbitral award. So, on the one side, Kebabji was trying to execute it before the English court. On the other hand, KFG was questioning it before the French court. In English court, they were not able to get it executed. Let's see what happened before the French court. So, KFG challenge to the arbitral award came before the Court de Cassation, which is the Supreme Court, which rejected the approach of the UK Supreme Court and took a diametrically opposite view and concluded that the law governing the arbitration agreement was French and not English law. So, this is something about which we have to be very careful. We lawyers and judges and the business community can talk, but then we all require a clear understanding by the respective countries who consider themselves to be sovereign in areas like this. So, with these few thoughts, I thank the organizers for having invited me for this Indo-German Arbitration Conclave, and my best wishes to all those programs which are going to follow after this. Thank you.
Thank you, Your Lordship. What an erudite speech. I think our German friends can confirm that he is not only master in Indian laws, but he is also an expert of German laws. Now, before we close the inaugural session and transition to the working session, may I request our President to give a book published by Bar Association of India called Supreme Court at 75 as a token of our gift. And may I request our President to give a concluding remarks on that.
Thank you. Since we are running into the next session's time, I just want to make one observation. When we are talking about BGB, there is a section 242 in BGB, which pertains to tre ungloben, which is good faith. And if German law was applied, the anomaly which happened in the UK and French dispute would not have been there, because this section provides an interpretative framework that all parties will act in good faith. And I think that is the need of the hour. If you want commercial relationships to sustain, if you don't want the dispute resolution to be a duel or a combat to death, you need to rely on this provision, this unique tradition and provision of German law to preserve economic value. So that is where I think this conclave is going to create an understanding which can be the basis for taking the entire dispute resolution framework forward in creating a new regime in terms of interpretative framework for resolving disputes. So thank you very much, and I think all of us stay here, and we'll have a quick turnover to the next session, and so that we can conclude on time. But even if the session was prolonged, I think the substance was so good that we are all thankful to each of the presenter. Thank you very much. We'll just have a quick photo.
We are now starting our next session in 5 minutes.